I am not here to guess or rant. I am here to read the record, explain the law in plain English, and tell you exactly what the Supreme Court is about to decide in Duncan v. Bonta. California's magazine capacity law targets what millions of Americans consider standard equipment, and after nearly a decade of litigation, the question has finally reached the doorstep of the highest court. I will walk you through what the case actually is, what the Ninth Circuit decided, why the petitioners pushed it back to the Supreme Court, and what the justices can do next. If you care about responsible ownership, training, and the right to choose reliable gear, this update matters to you. My promise is simple. No panic. No shortcuts. I will show you the stakes for ordinary people, the rules the court has already given us, and the practical outcomes that follow. By the end, you will know where we stand, what could happen after the conference, and how to stay both informed and lawful while the process plays out. What this case actually is. First, here is what this case actually is. Duncan v. Bonta is a constitutional challenge to California Penal Code Section 323110, the provision that forbids the manufacture, import, sale, lending, and possession of magazines over 10 rounds, with narrow exceptions. It began years ago in federal district court, where the judge concluded that the restriction violated the Second Amendment and blocked enforcement. During that brief window, commonly called Freedom Week, many Californians lawfully acquired magazines that exceed 10 rounds. After stays, appeals, and a remand from the Supreme Court to apply the newer test, the case returned to the Ninth Circuit Court of Appeals. In March of this year, an en banc Ninth Circuit affirmed the law. Petitioners then asked the Supreme Court to take review, and the case has now been set for a private conference where the justices decide whether to grant or deny. The path and timeline. To make sense of the moment, it helps to see the path. The timeline is straightforward, even if the docket is long. First, the district court ruled for the challengers and issued a statewide injunction. The rush of purchases during that period is why the phrase Freedom Week shows up in so many filings. Second, the Ninth Circuit intervened, partly stayed the judgment, and later sat en banc to reconsider the merits. Third, the Supreme Court decided a major Second Amendment case that changed the method lower courts must use. So the High Court sent several gun cases back to be re-evaluated under that approach. Fourth, after additional briefing and orders, the Ninth Circuit issued a fresh opinion that upheld California's law, and the challengers filed a clean, final petition asking the Supreme Court to resolve whether the government can ban the standard magazines that so many rifles and handguns are designed to use. What the Ninth Circuit said. What did the Ninth Circuit actually say? The majority framed magazines as accessories rather than arms. On that framing, the court suggested that the constitutional text may not even cover them. Then the court wrote that even if the magazines are covered, the state prevails by pointing to a historical tradition of analogous regulations. In practice, that reading treats modern magazine capacity limits as the rough descendant of older restrictions that targeted unusually dangerous weapons or storage rules. Several judges dissented. They argued that the majority evaded the Supreme Court's instruction to avoid interest balancing disguised as history, and that it misunderstood the common use principle recognized in earlier Supreme Court cases. The dissents also pushed back on the accessory label. A magazine is essential to the ordinary function of a semi-automatic firearm. If the constitutional protection turns on ordinary, lawful use by citizens, then a ban on the very components that enable that use raises a direct constitutional problem rather than a marginal one. Whether the Supreme Court agrees with the majority or the dissents is the question that matters now. Why this petition is different. Why is this petition different from other gun cases the court has declined recently? Petitioners emphasize that the record is complete, the judgment is final, and the question is crisp. They point out that prior petitions arrived in messy procedural postures, or while lower courts were still reworking their analysis after the Supreme Court revised the controlling test. In contrast, this case presents the core issue in a way that lets the court write a clear rule about magazines. The challengers also emphasize that standard capacity magazines are ubiquitous among law-abiding owners. That ubiquity is not a talking point. It is part of the legal inquiry, because prior Supreme Court decisions discuss weapons typically possessed by law-abiding citizens for lawful purposes. Finally, they argue that the absence of a clean split between circuits is a poor reason to wait, because the states that pass these bans fall into circuits that have often adopted similar reasoning. In other words, if the court waits for a neat split, the issue could remain trapped behind regional lines indefinitely. What a Supreme Court conference is and how it rules that govern. So what exactly happens at a Supreme Court conference? The justices meet in private, review the written petitions and briefs, and vote on whether to take the case. It takes 4 votes to grant review. After a conference, the court can issue orders that grant, deny, or relist a petition for a later conference. A relist is not a loss. It often means the court wants to study the record longer, to wait for a related development, or to prepare a separate writing. If review is granted, the case moves into a merits briefing and eventually an oral argument. If review is denied, the lower court judgment stands and the law remains in effect. Sometimes the court chooses a middle path, such as asking the Solicitor General to offer the federal government's view. That request can take time. It can also signal that a grant is likely after additional input. For the people who live under the law, the practical difference between those paths is significant, which is why clarity about the process is part of respecting viewers. Now let us ground the discussion in the Supreme Court cases that set the rules. In District of Columbia v. Heller, the court recognized an individual right and rejected judicial interest balancing that treats the Second Amendment as a second-class right. 2 years later, the court explained that the right applies to state and local governments through the 14th Amendment. More recently, the court set out a test that starts with text. If the plain text covers the conduct, the burden shifts to the government to justify its regulation by pointing to a tradition of analogous restrictions from the relevant historical periods. Lower courts are not supposed to weigh costs and benefits in the abstract. They are supposed to examine history and analogical reasoning carefully. That is the method that governs now. And it is the method the parties argue over in this case. When you hear the phrase text and history, this is what it means in practice. Impact for Californians. What does this mean on the ground for Californians? The statute at issue reaches manufacture, import, sale, lending, and possession. It lists limited exceptions and describes options that include removal from the state, modification to reduce capacity, or surrender. Because of the injunction history, people who lawfully acquired magazines during Freedom Week often ask whether their property remains protected. The short answer is that status has depended on court orders that changed over time, which is why the final outcome of this case matters. If the Supreme Court denies review, the Ninth Circuit opinion remains the last word in the federal system for this case, and the statewide restrictions stand. If the court grants review, the parties brief the issue, and the justices will decide whether the state can treat standard magazines as outside the amendment's protection or within it, but subject to historical analogs that justify a ban. Either way, responsible owners should continue to train, store, and comply with current rules while following the case through official updates. Clear minds and good records protect both people and rights. The Constitution draws lines that the government does not get to move simply because a policy sounds appealing. I do not insult my neighbors to defend a right we all inherit. I do not call for unlawful action. I do ask the court to apply the method it announced and to treat ordinary citizens with the respect that method requires. When courts relabel essential components as accessories and then discard them from the analysis, they do more than misname parts. They sidestep the basic inquiry about what Americans commonly and lawfully use to defend themselves and to compete and to train. If the court takes this case, it can give the country a clear answer that respects both text and tradition. If it does not, states will read the silence as permission to press further. My view is simple. Rights should not shrink because officials call something an accessory. The people deserve a principled line. Practical questions answered. Practical questions deserve straight answers. What does a conference date mean for timing? It means we will likely see a public order after the justices meet. That order might come the next court day or later, and it might be followed by additional relists. What happens if the court grants review? The parties exchange briefs on the merits, amici weigh in, and an argument is scheduled. That process takes months. During that time, existing state laws and any applicable stays remain in place unless the court explicitly changes them. What happens if the court denies review? The Ninth Circuit decision controls this dispute, and the state continues to enforce its law. People who hoped for nationwide clarity will need to look to other cases or to future terms for guidance. What should responsible owners do in the meantime? Know the rules where you live, train safely, document your equipment, and follow the case through official updates rather than rumors. Precision beats panic. Let us talk about civic engagement done right. The health of constitutional rights does not turn on outrage. It turns on informed citizens who read primary sources, support lawful litigation, and vote with clarity about what each office controls. State legislatures write statutes. Governors sign or veto them. Attorneys general defend them. Courts interpret them. Voters decide who fills those roles and what values they carry to work each day. Training ranges, safety classes, and community groups also matter. They build a culture of responsibility that proves critics wrong. When the public sees neighbors who handle firearms with discipline, store them securely, and speak with humility about the law, fears fade and common ground grows. That culture is as important as any single case. It makes it easier for judges to see the real people behind the briefs and to understand that constitutional text protects the habits of a free and responsible citizenry. On the conference date, 9 justices will review filings and decide whether to take this case. A grant means briefing, argument, and a path to a clear rule. A denial means California's judgment stands, and other states will take note. I will keep reading the record, speaking plainly, and treating you like adults. Stay trained, stay within the law, and stay engaged with primary sources rather than headlines. The Second Amendment is about responsibility and freedom within constitutional limits. Thank you for being here and for holding me to a high standard. We will see what the court decides next.